You've reached the stars. Now let's see you conquer a galaxy.
Good morning, distinguished ladies and gentlemen. I don't know if anyone can hear me. Would any of the panelists just indicate they can hear me?
Yes, we can hear you.
Okay, thank you. Once again, I'd like to say good morning, distinguished ladies and gentlemen. My name is Omoife Tiger, and I have the rare privilege to be the moderator for this session this morning. Firstly, I'd like to say it's an honor to have each and every one of us here as our guest this morning. And on behalf of the entire Meristem team, we want to say thank you and welcome to another edition of our Wealth Preservation series. And this morning, we'll be having a very important discussion on a very key topic, which we have titled Estate Planning in Uncertain Times, Define Details. Estate Planning in Uncertain Times, Define Details. And this event is being put together by Meristem Trustees Limited in conjunction with Meristem Registrars and Probate Services. As we all know, life is indeed full of uncertainties. And more than ever before, what COVID-19 has done is that it has prompted a widespread of economic uncertainty. Currently, there's so much uncertainty about our future, so much uncertainty of how long we would walk the face of this earth, so much uncertainty of what will become of our legacies when each and every one of us die. Much more importantly, so much uncertainty about what will become the future and fortune of our loved ones at our demise. But a wise man indeed once said, he said, the key is not to predict the future, but it is to prepare for it. It is to ensure that our loved ones are protected and secure in our absence. And so this morning, we want to talk about the very key subject, which is the fine details in planning our estates in these times of great uncertainty. We want to talk about the fine details in ensuring that the future of our loved ones are secured, even at our demise. We want to talk about the fine details in ensuring that our hard-earned legacies are passed on at our demise. And to do justice to this subject, we have in the house an esteemed panel of resourceful persons with vast experience in wealth management, estate and succession planning. We have in the house Mrs. Adetola Aniaru, Dr. Babatunde Oni, and the very managing director of Meristem Trustees, Damilola Hassan. So I'd like to urge each and every one of us to sit tight, be attentive, avoid distractions, because the next hour and 45 minutes will be interesting and exciting. Below your tab, you have the opportunity to ask questions. All of these questions will be answered, I can assure you that. So as the ship sets sail, I'd like to introduce Mrs. Adetola Aniaru, who would be our first speaker this morning. She's a senior associate at a renowned legal firm, SPA Ajibade & Co. She holds a master's degree in international business and commercial law from the University of Manchester. She's a member of several professional bodies, a member of the Nigerian Bar Association, a member of the International Bar Association, a member of the Association of Succession, Trust and Estate Planners, and she's currently the honorary secretary to that institution. A member of the Nigerian Maritime Law Association, a member of the Maritime Arbitrators Association of Nigeria, and currently she serves as a member of a special committee on probate section for the Lagos State Judiciary, alongside other senior lawyers and justices of the Lagos State High Court. Mrs. Adetola's experience in estate planning, succession planning, probate and other matters are unparalleled. She's an embodiment of knowledge in this light. And so at this junction, I'd like us to welcome Mrs. Adetola as she enlightens us on the very fine details in estate planning in these times of great uncertainty. Mrs. Adetola, the floor is yours.
Thank you very much, Omoife. I almost did not recognize who you were introducing, but thank you for the glowing introduction.
You're welcome.
Can I start sharing my screen now?
Yes, you can, please.
Okay, so everybody can be carried along in the presentation. So thank you very much, everybody, for joining us. Thank you for honoring us with your presence. My topic today is estate planning in general in these uncertain times that we are in. Of course, we all know what is going on around today with the pandemic, insurgency, kidnapping, and everything that is going on, not just in Nigeria, but all over the world. So that takes me to what Benjamin Franklin is remarked to have said, that nothing is certain except death and taxes. But of course, this is not to scare anyone or intimidate anyone into saying that because we know that we are going to die, we need to plan our estates. But it's something that we seriously need to start thinking about now that we are growing and we see everything that is going on around the world. Of course, crime rates are increasing, life goes on, things are happening around the world. And estate planning has assumed a very important role in the world, all around the world, at this time that we find ourselves in. So the more important it is for us to start paying very close attention to estate planning. So first of all, what is an estate? For us to even begin to understand what estate planning means. An estate includes the assets and liabilities of a person during his lifetime and after death. In other words, an estate is all the properties and monies owned and owed by a person. So an estate does not just comprise of what you own, it also entails what you owe people, because there is a common misconception in the estate planning industry that an estate comprises of what you have. But let's not forget our liabilities as well. There are a lot of people that have assets, but at the same time, they have borrowed money from the banks. So when you are calculating their assets, don't forget that there's also liabilities involved. And the estate does not just stop at the assets that they own. It goes beyond that and extends to money that they owe people or institutions. So apart from houses, cars, land, shares, debt, pension funds, life insurance, stock, personal chattels, it also goes beyond that and extends to debts that the person may have owed other people. So from there, what is estate planning? Estate planning is a process whereby a person deliberately plans and reviews how properties owned by them will be managed or distributed, especially upon death or incapacitation. Estate planning provides a person the opportunity of controlling his properties during his lifetime and even after his death. So estate planning does not stop at when a person has died or when in anticipation, something that is done in anticipation of death. It is something that can also be done. Of course, we don't anticipate that we are going to be incapacitated, but in the event that it happens, what plans do we have in place to ensure that we are well taken care of? We need to, estate planning extends to that as well. It also extends to what you do in your lifetime. So for example, now that we are all working, what plans do we have for retirement? Estate planning extends to that as well. What we put in place now in planning for life after our youth and when we have grown old and when we are retired, that is also part of estate planning. So many people may wonder, okay, people have lived, they've died, they've gone, life goes on. Why should I plan my estate? There are so many reasons why people like us need to start thinking about estate planning. Apart from the fact that most of us have families, most of us have children, most of us have people that depend on us for their well-being, for their everyday life. We need to start thinking about what happens in the event that we are not here. Who is going to take care of my children? Who is going to take care of the people that depend on me for their lives? In the event I become incapacitated, who takes care of me? The truth is that the absence of a plan will put your loved ones in a very burdensome position in the event of death or incapacity. And apart from that, if you don't take time to plan your estate, you are giving the state a right to direct the affairs of your estate. So if somebody has not written a will or a trust or whatever other mechanisms they want to plan their estate with, you are leaving a loophole for the state to come in and dictate how your estate will be administered by using the administration of estates law. So where a person has not sat down to plan their estate adequately, it's a loophole for the state to have a say in how the estate will be distributed upon death. And that stands the estate's risk of going to people that you as a person would ordinarily not want your assets to, would not want them to partake in your estates. So administration of estates law, for example, provides a list of people that will be able to benefit from a deceased person's estate. So in the event that maybe you don't want a particular child or even your spouse to benefit, by not planning your estate, you have left the gap open for that to happen by the interference of the state in the event you don't plan your estate. So another benefit of estate planning that it ensures that your family know your financial records, the location and details of properties after death. So how many of us now, things are getting better, but I had a personal experience that one of my uncles, he had a lot of assets in his lifetime, and everybody knew that he was a rich man, he had money. But when he passed away, okay, which bank did he bank with? Then it was Savannah Bank. But then, if information was not as readily available as it is now. We don't know his account number. We have no idea. We just know that, oh, uncle, this. So he used to go to Savannah Bank. Not knowing that apart from Savannah Bank, he had like many other banks that he used to use. He had a lot of money in those banks. If not for something that came to light like 5 or 6 years down the line, the family, they were practically impoverished after he died because they had no knowledge of where his assets were located, both liquid and real assets. He had land, he had properties in other parts of Nigeria that we had no knowledge of. So his children had to start living from hand to mouth, children that were well established before their father passed away. They had to start living from hand to mouth because they had no idea of how to collate the father's assets. So this is just one of many examples that I have knowledge of. So estate planning ensures that your family know your financial records because everything will be documented. You have the opportunity to write everything out. They know the location and details of these assets. If you have properties, if you have money in bank accounts, if you have stock, shares, if you have gold, if you have artwork, of course, estate planning gives you the opportunity to list everything out and everything is properly documented for anybody, well, for your authorized persons to be able to access upon death or incapacitation. Then estate planning may also help reduce tax liabilities depending on the estate planning mechanism that is deployed in planning an estate. So a lot of people plan their estates for so many reasons, some of which are to preserve family wealth. There are some big names, then that we knew, oh, this family is a rich family, but today, there's no information about them. Probably the children have, exhausted all the funds and all the assets the family had. But some people, they take time to plan their estates in order to preserve family wealth. They invest, they direct on how investments should be made to continually generate money for the family, even in their absence. So a lot of people deploy estate planning as a means of preserving family wealth. Another is to distribute assets, to provide for your children's education, to appoint guardians for minor children, and also provide for spouses or other dependents. And also, estate planning can also be used as a guide on how a person's business or assets can be managed. Then, of course, you can provide for charitable works with an estate plan. If you have a charity that you are supporting, an estate plan will provide the details of the charity for it to be able to continue in your absence. We can also use estate plan to list out burial instructions, especially for people that want to be buried in a particular type of way. So who needs an estate plan? Every adult, regardless of age or wealth, needs an estate plan. Of course, there is this misconception that, oh, I'm not old enough, I'm not yet 50, I'm not yet 60, I'm not thinking of death, I don't need to plan my estate. But I say that as soon as you start to acquire assets, at least you have a bank account that has a tangible amount of money in it, or you have a car, you have, assets that can easily be converted to cash where necessary, you have real properties, then you need to start thinking of having an estate plan. So it's not only for the wealthy or the stupendously rich. Even everyday people can have estate plan. You don't need to have a lot of assets for estate planning to be beneficial to you or your family. Because let's not forget that any amount of money, no matter how little, can become a source of problems and can cause conflict within perfectly normal families. So in the absence of an estate plan, you're only buttressing the opportunity for this to happen. But where you have an estate plan that has directed how your assets should be distributed, then everybody knows that, oh, when Mr. X was alive, this is what he used to do, and this is what he wants done with his properties when he's gone. So nobody is interfering. We all know about the proverbial brother that comes into the family once his brother is dead and takes control of the assets, to the detriment of the wife and children. So of course, estate plan avoids or reduces situations as this. So when should I plan my estate? Some people will ask. You can plan your estate as soon as you start to acquire assets. And it's not only when you're old, you can plan at any time. As soon as you start to acquire assets, that's what I say. No matter the type of assets you have, start thinking of planning your estates. So the activities of everyday life brings with it the possibility of serious illnesses, although I don't like to emphasize on this, but it is the reality. A serious illness or accident can happen suddenly at any age. Even with today's medical miracles, it could mean that you are temporarily or permanently unable to take care of yourself. So it's not only for your loved ones, it's even for you. God forbid somebody gets into an accident and they're unable, okay, let me give you a real life example. Somebody went for a surgery, and by the time he came out of the surgery, he couldn't write. He couldn't write, he couldn't move his hands. And of course, everybody was depending on him to sign checks or use his ATM card to withdraw money for them. Even after he gave his wife his PIN number to withdraw money from the ATM, it got to a point where the ATM was blocked, when the banks were suspected that something fraudulent could have been happening. And they had to access money in his account. So the wife was not a joint signatory to his account. And then we now have to start thinking of how to apply to court to appoint her as an attorney and all of that. But if there was an estate plan in place stating what could have been done in the event of his incapacitation, it could have saved us that trouble. There are many more examples like this, but this is just one of many. So estate planning should start sooner rather than later. And let's not forget that estate planning is an ongoing process. You must not only develop or implement a plan that reflects your current financial family status, you must also constantly review it and update your plan to ensure that it matches your current circumstances. So for example, somebody writes a will today and he has 5 properties. Tomorrow he sells 2 out of those properties. It will be advisable to review that will to ensure that it matches his current circumstances, so it doesn't cause problems for the executors or trustees in future. So estate planning doesn't happen once. Well, it doesn't necessarily have to happen once. If somebody plans an estate and then the eventuality happens, fine. But if you write a will, for example, or you set up a trust today, and 5 years down the line, it's most likely that your circumstances would have changed. It's most likely that the money that you already distributed in your will, maybe for example, it was 5 million naira. 5 years ago, you could have reduced to 2 million or you could have increased to 10 million. So you currently have to update your estate plan to reflect your current personal circumstances. So, I mean, it doesn't mean that you have to write a will every year or review your will every year, but as best as possible or as much as possible, ensure that it adequately reflects majority of your current circumstances. So, it doesn't cause confusion in future. How should estate planning happen? Estate planning is about making sure your assets are distributed both now and after you are gone. So to adequately plan your estate, you should consider and address the following issues. And these issues are: who takes charge of your assets? Which assets are you giving out? When and how should you transfer your assets? Who should draft your estate plan? Who should be your executors and trustees? Who should be the guardian for your children? And do you care whether or not costs are minimized or avoided so that the burden on your loved ones can be kept as light as possible? So for me, I advise that when you're doing an estate plan or when you're planning to write an estate plan, you have a table that is divided into two. To make things easier, the first thing you need to think about is, what do I have? So on one side of that table, you write, what do I have? I have 2 cars. I have properties here, here, and there. I have such personal chattels. You list everything out. Then on the other side, you write something like, who are the people involved in my life? So those people are divided into 2 categories. The people that you want to entrust with those assets, being the first, and the second being the people in whose favor you want the assets managed for. So the managers of the assets and the beneficiaries of the assets, you need to list that out. So if you're thinking of appointing your friend as an executor of your will, you write his name there. And of course, you write the name of your potential beneficiaries, which may include your direct family members, your children, your spouse, your siblings, your friends. So, I mean, in a nutshell, that is how estate planning should happen. One side, your assets, and the other side, the people involved in whose favor you want the assets managed for, and the managers of the assets. So we go on to discuss estate planning mechanisms. People plan estates in different ways. There are different instruments that you can use to plan your estates. And these include wills, trusts, power of attorney, gifts, family companies, etc. So we'll consider this and more in this presentation. So let's start with wills. The definition of a will is, it is a declaration of a person's wishes about the disposition of their assets and the management of their affairs after death. The person writing this will is called a testator or a testatrix. And a will is usually in writing, and names of the person who are to receive specific items of real or personal property and who are to carry out specific instructions in respect of the testator's affairs are listed in the will. That's what we discussed prior to now. So a will only comes into force when this person has died. So one cannot write a will now and then expect that the will will be executed when the person is still alive. The will can only be executed when the person has passed away. So there are different types of wills. We have the formal or standard wills, which is what we use in our everyday lives to plan estates most of the time. And then there are also special wills, which include non-occupative wills. These are oral wills, and they usually come to play when a person is in anticipation of death. So it's obvious that somebody is going to die, and they don't have the opportunity to quickly write out a will and then have witnesses execute the will. The person can, orally say, oh, I want my assets distributed as follows. We have situations where that has happened. I want my son to have this, I want my daughter to have this. So that's an oral will, which will come into play where the family is likely not to be in contention. And we also have holographic wills. These are wills that no witnesses are present. So the first example of the oral will, somebody can write a will without anybody being around, and it might be upheld depending on the circumstances that the person wrote the will without witnesses being present. Then we also have privileged wills. These are wills, special wills, which are made by sailors or soldiers or people that are in active service. They are privileged in that they are valid, binding, and enforceable without the required formalities which characterize a formal will. However, the testator must have the requisite testamentary capacity and intention of making the will. And we also have conditional wills and joint wills. And then we also have mutual or reciprocal wills. I don't want to go too much into detail since we hardly use these wills in our environment. What we usually use are the common wills, which we find every day. So what are the characteristics of wills? Wills are ambulatory in nature. We've spoken about this already. That means that it can only come into play when the person has died. Of course, it can be altered or amended, and a codicil can be written to support it. But a will only come into play or will only be valid to be executed upon the death of the testator. And then, of course, a will must be voluntary. That means somebody cannot be made to write a will or sign a will under duress. It has to be voluntary. It has to come from them saying that, yes, I'm ready to write a will or I want to write a will. It will be set aside if it is found to have been written under duress. What are the requirements for a valid will? The requirements for a valid will are twofold. That means testamentary, and this testamentary requirement has some cost components, which is, first of all, there must be an intention to make a will, and the testator must have testamentary capacity to make a will. And this testamentary capacity, they must be of age. In Nigeria, under the Wills Act, the person must be at least 21 years old to make a will under the Wills Act. However, in Lagos State, the will, the testator must be at least 18 years old. So in Lagos State, it is permissible for somebody that is 18 years and above to make a will. But under the Wills Act, the age limit is 21 years old. So let's note that. Privileged wills are an exception to this requirement of age, 21 and 18. That means that when somebody is in active service, if they're a soldier or a seaman, a seafarer, they are allowed to make a will if they are under the age of 18 or 21 years. Then, of course, the person must have mental capacity to make a valid will. It must be shown that the testator possessed a sound and disposing mind at the time he gave instructions for drafting the will and at the time of execution of the will, which means the time he signed the will and the time it was attested to by the witnesses. The formal requirements of a will are that, one, it must be in writing. It can be handwritten or it can be typed. And it has to be executed by the testator. And the signature must be original. So we've seen a few cases, very few cases, where a scanned signature was attached to a will, even though it was witnessed by, well, it was supposedly witnessed because obviously the witnesses were not there when the testator allegedly signed the will. It was supposedly witnessed. It will be set aside. This is a ground for it to be set aside. So a scanned will, even the Evidence Act does not allow electronic signatures to be placed on wills. It has to be signed originally by the testator. And it can be a scanned signature or a photocopied signature. Then the cost implications for writing a will. The expenses of estate planning via probate can be broken down as expenses incurred in the will drafting stage and expenses incurred upon the execution of the will. The bulk of the expenses are at the last stage. And in the will drafting stage, the fees to be paid are as follows. First, the solicitors or practitioners' fees. The person that wrote the will have a fee for this will writing exercise. So that has to be paid. Then there's also a will lodgement fee. So after you write a will, the provision is that it has to be lodged at the High Court of the state in which you are writing the will. That's the probate registry of the High Court. There's a probate registry there. You have to take the will there for it to be lodged. That means to be kept in the safe custody of the courts. So after the person has died, you can now go and apply, the family members or the solicitor, whoever has knowledge that a will was lodged there, will apply for the will to be retrieved and read. Then after that, you apply for grant of probate. So it is not enough for us to write a will and keep it at home, keep it in our safe, under our pillow. You have to take it to the High Court for it to be lodged, especially in other parts of Nigeria. Otherwise, at the end of the day, you might end up applying for letters of administration. Some people will allow, some provisions in other states allow for you to apply for letters of administration with will annexed. But if you don't lodge the will in the High Court, you have to apply for letters of administration in most states. But in Lagos State, where you have written a will, properly written will, executed and attested to, you can lodge it as a detached will, even after the person has died. So if you don't lodge it after you write the will, you keep it at home, and the testator passes on. If that will is found by the family members or whoever was in the house, you can quickly take that will to the court for it to be lodged as a detached will. That is permissible in Lagos State only. After the application, they will inspect the will. If it wasn't properly sealed, if it was properly written, they will advise that you seal it and you can lodge it as a detached will. If it was sealed, it will be accepted and lodged as a detached will. After that, you can now apply for a reading of the will. So let's not forget, it's very important that after we write our will, we take it to the court for lodgement. A lot of people do not do this. They just feel that it is enough for you to write a will and keep it in your safe or keep it somewhere in the house. But don't forget that there's another step after you have written your will. It has to be lodged. I can't emphasize that enough. And of course, there's the lodgement fee that you have to pay to the court. In Lagos State, it's 10,000 naira to lodge a will. That is after you have written the will and you take it to court, 10,000 naira lodgement fee will be paid. But if the person has passed away and the will was found at home, you want to lodge it as a detached will, there are 2 layers of costs that you might need to pay. If the will was brought to the court immediately after the person died, you are still going to pay 10,000 naira. But if the will was brought to the court 3 months after the person died and above, the cost for lodgement is 50,000 naira. To lodge as a detached will, you have to pay the sum of 50,000 naira if you apply for lodgement 3 months after the testator has passed away. So after this will writing and lodgement exercise, and somebody has passed away, you want to now read the will and apply for grant of probate. Certain costs need to be paid. The cost implications are as follows. Of course, you pay your filing fees, your application fees, 2,000 naira, and then you pay your oath fees depending on the documents involved in the filing process. Then you also pay your estate fees. Estate fees are all the fees comprising of the assets that make up the assets that have been declared by the applicants, who are the executors in this case, or the solicitors to the executors. So they are in 2 layers. They can be monies in the bank. In fact, there are more than 2 layers. Monies in the bank, assets, real assets declared, and shares of blue chip companies or private companies is in three layers. So this cost will be calculated by the probate registry, and a probate pay sheet will be issued for you to go and pay the probate fees. So those are the cost implications when you are using a will as an estate planning mechanism. So what is the time frame for executing a will? A grant of probate or a will may take a minimum of 2 to 3 months to obtain. So, I mean, some people might come for me here. Why I say 2 to 3 months is because ordinarily, if you have a will that you have lodged, you have applied for it to be read, the will has been read, you apply for your grant of probate immediately, you submit it to the court, and the court says, okay, so you need to pay so. You need to pay so amount of money for the bank certificate, you need to pay so amount of money for the inspection, the property that was inspected, and you need to pay so amount of money for the shares of the companies that were declared. You take the pay sheet court and you come back to court immediately and you pay that money. You are guaranteed that your grant of probate will be issued within a minimum of 3 months if you follow up adequately. If you follow up and you ensure that your file keeps moving from table to table. Yes, we've obtained a grant of probate 3 to 4 months because we wasted time in paying the estate fees. So a lot of people say, oh, why does it take so long? Anyway, let me finish my presentation. I'm sure that will come up in the question and answer session. But, sometimes some people, are lost as to why it must take so long for the court to issue a grant of probate. Most of the time, the fault comes from us. So that is another topic of discussion for another day. Let's move on. So we have another estate planning mechanism, which are trusts. I'm not sure if Mr. Oni is still taking this aspect. Mr. Tiger, can you confirm if Mr. Oni will still take this aspect so I can skip it?
He wouldn't. So I think you should just seize the opportunity to talk quite extensively on it.
Okay.
But however, because of your timing too, maybe within the next 10 minutes, so we can entertain questions. There are quite a lot of questions for you to answer.
Okay, so I don't want to go so much into the legal aspects of a trust. A trust is just what it is. When you say you trust somebody, we all know what it means. That means that you can trust that the person will do anything you want done in your absence under these circumstances. You are willing to give the person whatever it takes to ensure that your desires are met in line with the way you have said it should be done. So that is basically what a trust is. I have an asset and I've appointed somebody that is called a trustee, that when I'm not here, I want you to manage these assets for the benefit of somebody else that is not me, or can be me if it's a living trust. So in my absence, please manage these assets for the benefit of this third party. That's what a trust is. So the first party is called the settlor, the second party is called a trustee, and the third party is called the beneficiary. So there are 3 parties involved in a trust. So it is typical for a trustee to manage an asset for the beneficiaries, most of the time children, or even the person that created the trust, by paying out income when the trust crystallizes. There are certain principles that govern the operation of trusts. So constituting a trust refers to the transfer of assets from an individual to another individual or group of individuals. It can be a company as well that can be appointed as a trustee for the benefit of a third set of individuals. So we have living trusts, and then we also have testamentary trusts. So living trusts provides instructions for the management of a person's assets. Okay, let me be practical here. So if I say I want to set up a trust and I've approached a trust institution, for example, I have assets that have been titled in my name. These assets can include liquid assets and real assets. If I have money in my bank, I have to move it to the trustee for the trust to become operational. if I have property in my name, I have to transfer the property to the trustee for the trust to become operational. We see a lot of things that are going on now, which are probably going to be problematic in future, where there is no transfer of assets. That is what a trust is. There has to be both a physical transfer of assets and a legal transfer of assets. So if you want somebody to manage your assets on your behalf and you have created a trust deed, you have appointed a person as a trustee, you have to transfer your assets to that person for the trust to become operational. If you haven't done that, the trust cannot be operational. That is basically what the law provides. However, a living trust specifically addresses how a person's affairs should be managed during any period of incapacity and can serve as a vehicle for managing financial assets during such period of incapacity or mental disability. This is not stricto sensu, in the sense that you don't have to be incapacitated or disabled to create a living trust. So you can transfer your assets to somebody for them to manage it on your behalf and pay you dividends or interest on the management exercise. So if you have decided to open a trust account, you will need to get your assets titled in the name of your trustee. But in Nigeria, we're still going through some processes in ensuring that we perfect our trusts, in the sense that it's expensive for you to say that you want to create a trust. After you've paid all the setup fees, you now go ahead to transfer your assets to that trustee. That means that you have to, if you want to transfer real assets to the trustee, you have to register a deed of assignment in favor of your trustee, or you have to assign your property to your trustee legally. And we know the cost of, well, we know that it's very expensive for you to do that at the lands registry, not only in Lagos State, even outside Lagos State. So it's prohibitive costs has not made trust get a very secure footing in Nigeria. Then we also have testamentary trust, which is very similar to a living trust. And the main difference is that the testamentary trust only becomes effective upon the death of the testator. So the beneficiaries can only access the assets when the testator has died. So it's more or less like a will. So that's what we refer to as the testamentary trust. What are the requirements for a valid trust? We've spoken about this. Number one, there has to be certainty of words. That means the settlor must manifestly express his intention to create a trust. In words, he has to write it down. It has to be a trust deed. A certainty of subject matter. The subject matter of the trust is the property upon which the manifest intention of the settlor is going to operate. First, the settlor must specify the property, which is to be the subject matter of the trust. So you have to list the assets that you want to comprise in the trust for it to be a valid trust. Then certainty of objects. For a trust to be valid, the objects of beneficiaries of the trust have to be clearly ascertainable. This is of paramount importance. So if you say you are creating a trust and you have not mentioned the beneficiaries, that trust cannot become operational. So what does it take to set up a trust in Nigeria? To set up or constitute a trust, the settlor needs to undertake the following steps. Number one, he has to appoint a trustee or a group of trustees. This trustee can be an individual or a firm or a company. Then number two, there has to be a specification of the type of trust to be created. A trust could be express or implied, public or private, living or testamentary, revocable or irrevocable. This classification is not watertight, however, as certain trusts embody more than one of these categories. For instance, a trust can be both living and irrevocable, but a settlor has to specify the type of trust he is creating for the trust to be properly constituted. So where I see that we make a mistake is that there is usually no legal transfer of assets to the trustees. And this is the most important part of a trust instrument. If you are setting up a trust and you have not transferred your assets to your trustee, believe you me, you have no trust. So the mode of transfer depends on whether the assets are real or liquid. So an instrument of transfer is needed. This is the trust deed. And then apart from the trust deed, there has to be, for example, if it's real property that is involved, a deed of assignment or a deed of transfer has to be executed where the settlor moves his property to the trustee. It has to be perfected and registered at the Lands Bureau. All the necessary fees have to be paid. This is mandatory for a trust to become operational. For liquid assets, there is no requirement of a direct transfer. But let us note that there must be a provision that the trust will have access to those assets once the trust materializes, meaning that when the condition precedent has happened for the trustee to access the trust assets, there must be no limitation to this. So if there is money in the account and you say you have created a trust in respect of those funds, if the trustee cannot access the money at the time required, then you don't have a trust. So it's either you add the trustee as a joint signatory or a signature in the event of any eventuality for him to be able to access that money. Otherwise, you have not created a trust. So we should bear that in mind, that this trustee that you have appointed should be able to access your assets as at when required. So the monies may also remain in the account, but the situation is that the trust deed executed between the settlor and trustee will contain that the monies present in the source accounts and the powers of the trustees to these monies. It is important for the trust to have the authority to access these funds for distribution upon the fulfillment of the condition, contingency, or event stipulated in the trust deed. So you can decide that you want to move the money to the trustee, or you can remain in control of the money. But when the trust materializes, or when the trust is supposed to materialize, that trustee must be able to access that money. And the only way you can do this is to add them as a signatory to the account where the monies are being held. So a trust can be created by a deed or even a will if it is a testamentary trust. Whatever mode, the instrument operates to formally appoint the trustees and specify their duties and powers, amongst others. What are the costs for setting up a trust? Trusts can be expensive, especially where the trustees are a firm or company. The fee and expenses which most likely will incur are the setup fees, usually one-off, the trustee fees, management fees, estate gathering fees, funds to open the trust account, which is an initial capital fund, and the settlor is not mandated to transfer any fund to the trustee to open the IFC account. Other expenses may also be required. The time frame for setting up a trust, well, depends on the type of trust that is being created. So, well, it depends on also the trustee that is involved, if it's a company and the other requirements that need to be fulfilled. So it can be short and it can be long, depending on the type of trust that you want to create. So that's it for trust. Let's move on to gifts. I'm sure I've spent more than my required time, but let me quickly run through. A gift is a gift. You are giving somebody a gift, it is a gift. But of course, like a trust, you have to make sure that you are giving them free of any conditions. So it's a voluntary transfer of property without consideration, and it occurs between two parties. One is the donor and the other the donee. It can be it has to be during your lifetime. And then the requirements for the validity of a gift are, there must be a delivery of the object of the gift, and there must be an intention to make the gift, and the donee must accept the gift. So if when you are gifting somebody an asset, of course, if you are gifting them money, all you have to do is transfer the money to their account and say, oh, in my lifetime, my son, I've given you the sum of 5 million naira, do whatever it is that you want to do. If you want to give them property, you tell them, oh, this property at so place, I've given you, but it doesn't stop there. You have to execute a deed of gifts, and you have to go to the land registry to register the deed of gifts in favor of the person that you are gifting the gifts to. So it's not enough for you to orally state, or even sign a document that you have gifted somebody a gift, you have to ensure that it's duly registered at the lands registry. And of course, the person has to accept the gifts. We have what we also call a lasting power of attorney, which is an estate planning mechanism. It doesn't really have a strong footing in Nigeria, but it can come in handy where incapacitation happens. So if you have a power of attorney that you have drafted that in the event of so eventuality, I want this person to be able to take decisions concerning my care and welfare, you can write that in a lasting power of attorney and it will become operational in the event of incapacities. Then we also have family companies. Some people they incorporate companies and make all the family members shareholders and acquire assets in favor of the company. So if one person dies, that doesn't necessarily mean that the company has died. The other members of the company will continue to operate the company and have the person that has died, the shares transferred to the other members of the company. It's a very simple mechanism that we don't really have a lot of time to talk about today, but hopefully soon we'll be able to talk about it. So in conclusion, it is obvious that the above listed instruments can be effective methods of estate planning, each in their own rights. Of course, you have to consider the cost implications and the personal circumstances of the estate planner in arriving at a decision which sole purpose will be to protect and preserve his or her assets for the benefit of specified beneficiaries. It is very vital that the services of a specialist legal practitioner or a specialist probate practitioner be engaged in making estate planning decisions to ensure that the choice best suited for such an estate can be made. Thank you.
Thank you. Thank you so much, Adetola. This has been very insightful. You've touched on a lot of key subjects, especially with regards to the timing in probate delivery, and I'm glad you acknowledged the fact that a lot of people will call for your head on that regards and in that respect,
Yeah.
Okay. Just before we delve into the questions, particularly I like to take it from the angle of letters of administration, procurement of letters of administration. I like the way you ended it, where you talked about you need the professional services of a professional to guide you in all these estate plannings and the likes. We've seen series of cases where people come to us, particularly to our probate desk, and say, hey, I've been trying to get a letter of administration for the last 6 years, 7 years. My lawyer, they're not following up on it 4 years. And we've had several experiences like that. I'd like you to address that. But just before you do that, we have someone who is on this call who was served by Meristem Probate Services with regards to the procurement of a letter of administration. And she would just like to say a few things about the experience in the next 5 minutes. So Moralake, I don't know if you're on, if you can speak to us and then within the next 5 minutes on what your experience was like in getting the letter of administration for your deceased mom.
Yes, okay. So I think I lost my mom 2019, mid 2019. It was sudden, obviously. Nothing, no warning, no nothing. So no preparations. I don't think you can ever be prepared for death anyway. But the estate was how do I call it now? A challenge. Just organizing things, Luckily for us, we had an idea of accounts. We even had passwords we had the pins and everything and all of that, but because of, the government issues and the fact that withdrawing money just to immediately something like that has happened can be termed fraudulent, we just decided to just look for someone that could help us process it. We had already spoken to a couple of people. We're going to do it by ourselves.
Moralake, we can't hear you. Are you still speaking?
Can you hear me now? Yes, I'm still speaking.
It's better now. Couldn't hear you before.
Hello?
We can hear you now.
Oh, okay. Sorry about that. My network is terrible. Can you hear me now?
Yes. Go ahead.
Okay, please, where did you lose me? So that I can just continue from there, please. Sorry.
You couldn't access the money in the accounts.
Oh yes, so because it was going to be considered fraudulent, even though we had all the pins and everything, access to our accounts like ATM cards, we needed someone to help us. So we'd asked around for those that lost their loved ones, how they handle things like that. Some people, it took them 5 years to do it personally. Some of them, it was they had tried and they had totally given up because they just thought the money couldn't be as stressful as them doing it by themselves and going to each bank just to get letters and things like that. So someone introduced us to Meristem. We personally worked with them on my fair Tiger as well on just getting everything. Um, I think from 2019, I think we started maybe September or November then. And then as of right now, we have the letters of administration. We're trying to open like an estate account. That took us, I think, roughly about 9 to 12 months. Of course, some of the delays were from our end as well, because you need to look for certain documents, sign certain things, and just, there's a constant feedback. It's not a monologue, it's a dialogue. So as much as they're putting in their efforts, you also have to be putting in yours. So as they're requesting for information and the authorities or signatories to the account, you also have to be available. Sometimes I felt like they were the ones chasing me just to get it out. But so far we have the letters of administration, and now we're trying to open an estate account. Even though they had finished their own process, I remember asking on my fair like for help in terms of which bank would be the best to open an estate account already, like because she already had an account with the bank that we're looking at right now. He still helped and was very willing to help in terms of linking me with someone in the bank to just help the process be faster. So I would say that they're quite supportive and they will go at your pace. So if you're slow, then you will have to make do with what you have. But if you're fast and you can get everything out, then you should be able to get everything faster, and it's less stressful because you don't have to keep going to all the banks by yourself. So from that process, just ask all the questions that you need to ask, and I think that you'll be fine. They've been helpful so far, and it's 2021, and we have what we need for now. So that's what I have to say. So am I supposed to? I don't want to oversell Meristem, but I'll just say they've been very supportive and they helped get the papers out. I'm still talking to people that haven't gotten their letters out, their probate. The process is really long and very stressful, especially when you are mourning and you don't want to really deal with stuff like that. It was quite a supportive process. So that's what I like to say. Thank you. I hope you heard me and I wasn't talking.
Okay. Thank you, Morolake, for the testimonial. I think one of the reasons why we wanted you to speak firsthand to your experience, to let people know that if they seek for help, in the right places, the process can actually be shorter, and there's less headache for you when you seek help. So we're very much available, to provide the help that is required, either at the estate planning level or even post-demise, where the issues of probate and grant of probate and letters of administration become necessary. We're very much available to provide a helping hand. Okay, we need to go straight into the question and answer. Omoife, I think he's had a bit of challenge with his network. Ifunaya, so do you want to hold forth for him? I know some questions have been answered back end, but you may want to quickly, because we need to let Adetola leave. She has to attend another meeting. So we need to quickly look through the questions that we require to answer live. I have one or two here. So I think I can start up with that. Is that fine?
Yami,
yes. Okay, so there's this question about for individuals who have assets abroad, especially real estate and other liquid assets, and they reside in Nigeria, what do you advise as the best form of approach to planning their estate?
Okay, so for me, I think the best form is writing a will. Why? Because a will can be resealed. This means that once you apply for a grant of probate in a particular jurisdiction, for example, if the person died in Lagos State and they had assets in Lagos State, you apply for a grant of probate regarding the assets in Lagos State. After that, you can move on to the UK, if the other assets are in the UK, and reseal that grant of probate. You have the authority to ask the probate court in the UK to give you like an addendum grant of probate for you to be able to take charge of those assets in the UK. A resealing procedure is very simple. You apply, you pay the fees, they do evaluation of how much you're supposed to pay to them, you pay it, and they give you the addendum grant of probate to deal with the assets. So I think a will will be a better estate planning instrument for people with assets in multiple jurisdictions.
Absolutely, I agree. Okay, Omoife, you're back, so please.
Yes, thank you. Thank you so much. I had issues with our network. Okay, Mrs. Adetola. There are a few questions also here. Someone raised his hand. I don't know if we've taken in one, Mr. Thomas. He wanted to speak on, he had a question to ask, and I'll be glad if we can have him speak. Thomas, are you still there? Okay, we have Adebayo Abiodun. So Adebayo Abiodun, let's hear you.
Omoife, can I suggest we run through the questions in the question and answer box?
Okay, whilst we're waiting for that.
Yes.
Okay. There's a question here. It says also for the next of kin, is there an arrangement for the transfer of assets to a next of kin without having to go through the probate process?
Yes, we discussed it. It's gifting. You can gift it to them in your lifetime. If you don't want to go through the probate process or the trust process, you gift it to them. If you know that you want your son to have this property or the money in this account, you give it to them in your lifetime.
Okay, that's good. That's good. Okay, another key question, Mrs. Adetola, on the issue of trust, which you spoke about, and the attendant cost that comes with having to move all of those properties to the trust, especially when real estate properties are involved. The way it is here in Nigeria, is that how it's also applicable in overseas countries?
Absolutely not. Because the reason why it is like that in Nigeria, we have, well, I have knowledge that we are still in the process of passing the trustee law or act into law. So ordinarily, if you are setting up a trust, you should just pay a little fee for your assets to be transferred from the settlor to the trustee without having to go through the registration of title process, which is what happens at the Land Bureau. So it is not like that in other jurisdictions. It's definitely not like that in the UK because there is a nominal fee that you pay for setting up a trust, and all your assets are automatically transferred to your trustee without having to do registration of titles in favor of for the benefit of the trustee. So other jurisdictions, to the best of my knowledge, in the UK, in the US, it is not like that.
Oh, great. I hope you'll be able to have that law passed as quickly as possible. Now,
yes,
there's another key question someone is asking here. He says, is the winning strategy to creating a trust? What is the winning strategy to creating a trust, basically?
Okay, so if you already have assets that are titled in your name, it may be difficult because you have to go through the transfer process. But if you are planning to purchase assets, you're in the process of buying assets, then you can set up a trust and buy the assets in the name of the trust. So directly it goes to the trustee. It doesn't even come in your own name. Automatically the assets are acquired in the name of the trustee, which will help them now manage it for the benefit of the beneficiary, that you also can be a beneficiary to that trust. I hope you understand. So you don't have to go through the process of transferring title to the trustee.
Perfectly.
Yeah, Omoife, let me quickly say this. I think what is important for people to know is that we are unique. We have different situations and circumstances. So it's important that as an individual, as a family, You look at your family circumstance, you look at your situation as that individual to now then determine what estate planning tool to deploy. For some people, you will need more than one. You would need a combination of a will and a trust. For some people, just executing a will, a comprehensive will, is all that you require. But what is your situation? So if you're an individual with a wife and children, but you have one or two kids by another woman somewhere, and you're legally married you're married under the act to your wife, but then you have, so you could have a bit of complex situation in terms of your family. Just having a simple will may not suffice for you given that situation. So by and large, each individual needs to look at their own situation, speak with a professional, and that's why we're here. Speak with a professional, explain. So when you come to have that conversation on estate planning, we always like to describe it as, it's like a conversation with your physician. The same way you do not go to your general physician and begin to package what exactly is going on with you, with your health. You have to come clean with what the symptoms are, what the issues are, so that you can get help. That's the way it should be. And we also need to let people know that the information they bring to us as they discuss their personal circumstances, their information is secured. Confidentiality is one key thing that we are guided by, and we ensure that whatever information we have, it is well protected so that we work with the individual to achieve their estate planning objectives at the end of the day.
Great. Thank you, Damilola, for that. Tola, one key question, and I'm going to ask this question in the light of what happened with Kobe Bryant. Kobe Bryant, the amazing basketballer who passed on last year with the daughter. The good news was he had an estate plan in place for the asset of what, over $600 million. But something was found wanting. The last daughter, who was 6 months old, barely 6 months old when he passed on, wasn't included in the trust. And they recommended that the trustees have written to the court to make an amendment to that trust to include the last daughter who wasn't included. Is that possible?
We discussed this as well, that your estate plan must always reflect to the best position as possible, your current circumstances. So Kobe Bryant probably set up that trust maybe prior to when the daughter was born. So he did not review it after that child was born. So, well, it depends on what the court decides. If they provide enough evidence, and make a case for the daughter, maybe the court will decide in her favor, but that's not up to me. I don't really know what their law provides if that is, possible. But ordinarily, a trust or an estate plan should reflect your personal circumstances to the best position as possible. That's why we have to constantly review our estate plan.
So in that situation, would you blame his trust advisors, his estate planners, or what would you do?
No, not really, because the child was just 6 months old. Maybe if the child was like 5 years or 3 years old, then of course a lot of time had passed. But I don't know. I hope the court decides in their favor. I won't blame anybody for that.
Okay, Mr. Detola, another key question here. You currently serve on the committee, a special committee on Lagos State Probate Committee, as it were. You said letters of administration can be gotten within 3 months. In reality,
of probate, grant of probate.
Grant of probate.
Yes.
But in reality, Mr. Adetola, that is not the case. But what I like to find out is, are there strategies being put in place to ensure that the probate process is seamless within Lagos State? At least, like you said, in 3 months, actually, a letter of administration or a grant of probate can be gotten. Is there anything the state government is doing to review these processes? Because truthfully, it is cumbersome.
Yes, I agree. You remember that in 2019, the previous administration under Justice was the one that set up this probate committee, and set up the e-filing probates where you could apply for letters of administration online. So the goal of that exercise was to, as much as possible, streamline and reduce the procedure, and the time for applying and getting letters of administration and grants of probate. However, and this procedure was ongoing. Of course, it was work in progress. I won't say that they had perfected it and people were able to get letters of administration under 6 months, under 4 months in record time. But things are worse now, definitely, as a result of the looting of the courts and the carnage that went on during the civil unrest. So it's like we are starting all over again. That's the truth. So also we too, as users of the service, we have to put ourselves in their position. You can imagine coming to work one day and all the files, everything, all the computers have been taken away, probably information that wasn't even backed up in the server, they lost everything. So it's like we're starting all over again, especially for the probate registry of the Goshere. They've now relocated to Ikeja. So let's put ourselves in their position. We don't expect that things will automatically start to happen, today for something that happened yesterday. It was very unfortunate, but I know that in the process of ensuring that things get back to usual as soon as possible.
Great. Thank you, Mr. Detola. Damilola, this question is for you particularly. On living trust, precisely living trust, what would you say Meristem Trustees is offering in that regard? Private trust, with regards to living trust and a private trust, as it were. What would you say Meristem Trustees is offering in that regard?
Okay, so as a firm of professionals, what we basically try to do is to sit with each client to understand their situation. What stage of life are you? What's the prevailing situation at your end there? And you would agree with me that if we have 10 people, you will have 10 different situations that apply. So the beauty of the private trust is that it allows you to customize. It's quite flexible, such that you can tweak, to meet the individual's needs, as long as the 3 key things are in place. The settlor is identified. That's the individual who wants to establish a trust is identified. The beneficiaries have been identified. And of course, there's a trustee that has been identified to hold those assets in trust. Another conversation that we always like to have is to look at the financial implication. Adetola mentioned earlier about, do you want, as an individual, do you want to spend the money, incur the cost now, and save your loved ones, your beneficiaries, save them the stress of having to incur the cost of transmission and all of that when you're gone? Or do you want to defer that expense? So either way, you look at your situation. Do you want to defer that? Deferring that expense means that you do not want to transfer those assets while you're alive. So you can't have a living trust. You probably want to put together a will, or you want to have a testamentary trust. So the cost of transferring those assets will be deferred until you're gone. So an individual needs to look at that. Either way, you will still spend money. So you just want to decide, do you want to spend the money now, or do you want to defer that? Also, we have issues around the nature of the assets that you want to transfer. Adetola had spoken about that earlier. Some assets are very easy to transfer. So imagine if you're transferring a portfolio of stocks to your trustees. The process is quite simple. You work with your stockbrokers, and then those shares are transferred and they are held by the trustees. Whereas for some others, like real estate, it's a bit more difficult, simply because the process of transferring real estate is tedious on its own, and then there's also the cost. So we look at that. For an individual who has a lot of real estate and they're in their personal name, individual names, we advise sometimes, why not go the route of a will? especially if you do not have plans to dispose of those assets. You know, so there are different situations that would arise, and we would always look at each person on a case-by-case basis and then try to profile what we think is the best solution for you and your family.
Great. Thank you, Damilola, for that. Adetola, there's one question for you, one more question. But just before I ask, I'd like to announce that there's a poll that will be displayed right now on the screen. Distinguished ladies and gentlemen, I'd like you to please oblige us, answer all of those questions, and it will be of great benefit to you and to us. Thank you. So, Adetola, this is a very key question, which is, can a trust be used to conceal the identity or the ownership? Can a trust be used? Can it be used to conceal the true ownership of a property? Why have I asked this question? Someone referred me to a man who said he had about 21 properties, 16 of them were in real estate and the others were landed properties. But he wants to conceal his identity as the owner of these properties. For some of them, he hasn't perfected legal ownership of them. They still are in the names of persons he bought them from. For that kind of person, what would you advise? You see the trust, what special vehicle would you put in place for him?
Honestly, it's a tricky question because I think it depends on the motive behind the concealment. You have to examine the motive behind the concealment. If it's for fraudulent activities, then of course, this is something that your company will not want to be involved in, you know. So you have to examine the motive for the concealment. Of course, a trust can be used to conceal the identity of the true owners of the assets. Yes.
Okay.
So quickly, let me just say that it's typically to provide for confidentiality, you know. So let's always remember that with a will is a public document, right? Public document once it is opened and read. I mean, so you can write to request for anybody's will, anybody's will as well. You can ask for that document and it's a public property. But with a trust, it is very different. It's confidential. It can be kept confidential. The details of your assets and all of that are kept within your family and the individuals that are involved in that trust arrangement. So if it's just for the purpose of confiding, protecting your your details and providing that confidentiality, yes. But definitely if it is for any sinister purpose, then the whole objective is defeated from the get-go.
So, sorry, let me quickly go to Boyega's question because it relates to what we just spoke about now. Boyega Sadiq is asking, how is confidentiality of information ensured when wills are lodged at the High Court? This is because the will may contain sensitive information that you do not want known to potential or excluded beneficiaries at the time of writing. So I believe Damilola answered that question when she said that a will is only opened upon the testator's death. So when you want to lodge a will at the High Court, it is sealed with red wax. It has to be sealed. Nobody knows the contents except the writer of the will, the testator, and probably his solicitor that drafted the will for him. You seal it and you lodge it sealed. Nobody has the right to open it. Nobody is going to open it. So it remains confidential until it is read, which only happens when the testator has died. So Boyega, I believe that should answer your question. There are many questions here, Omoife. I'm seeing a lot of questions that I think are very important, and I don't know how fast we can run through them.
Yeah, a lot of those questions have been answered. So if you look at the Q&A, they've moved to the answer segment, but we still have, I think, 2 more that haven't been answered. I think there's one here talking about who are the beneficiaries for an individual who dies intestate in Nigeria. Individual is married but has no children. Are you able to perform any service under this dispensation? Omoife, do you want to take that? Did you get that question?
Please read it over again. Actually, I could hear you clearly.
The person is saying someone dies intestate. this individual is married but has no children. Are you able to perform any service, you know, in this regard to help in the situation that someone dies intestate, is married but has no children, you know?
Okay.
So this is not, the person is dead.
Yeah, so currently within the Lagos state laws, there are persons who have been identified to be administrators to an estate. It starts with the spouse. So the first question is the spouse still alive? There are no children, that has been established. Does the person have siblings? Does the person have step siblings? Does the step siblings have children? So the law have identified an array of potential administrators to the estate of the deceased. So in the finality where there is nobody available, you know, the auditor, the administrator general of the state would definitely take charge. So it's possible. So the person needs to clearly answer this question. We need to extray all the potential administrators that are available. If none exist, then the administrator general of the state would take charge in the administration of that estate.
If this person is married, so if the person is legally married, I would have thought that the direct
should be the spouse,
the
wife,
obvious
the husband. I said should be the spouse, the wife or the husband. Yes.
But it's not.
Adventure is there.
But it's not given, right?
It's not exclusive. Yes, it's not exclusive to the spouse because there's a list of priority of people that are potentially entitled to benefit from that estate. So if you can establish that the brother or sister is still alive and he was taking care of them when he was alive, they too, they have a right to claim in the estate. If you can establish that he had aged parents that he was taking care of when he was alive, that means they too, they have potentials of, they have the right to benefit from the estate. So it's not exclusive to that spouse, man or woman. So, you know, there has to be, every circumstance has to be properly considered.
Okay, thank you, Adetola, for that. There's one more question here. I don't know what the person is trying to ask. He says, what is the qualification or requirement for becoming a trustee? You know, that's tricky. Is it a trustee as a firm, or are you trying to say assessing a trustee service? I want to believe that is what the person is trying to ask. Damilola, would you want to shed light on that?
No, I think this person is trying to know what, you know, a trustee can be an individual and it can be a corporate. So you can, as an individual, you can choose another individual as you can name another individual as your trustee. You know, but like Adetola already told us before, if you have a trust in place, there must be the transfer of assets, you know, to the trustees, right? You know, so for an individual, there's no qualification, as it were. All you need is someone you can trust, and because you'll be transferring your assets to the person. So the question you want to ask yourself, if you are appointing an individual as your trustee, is what if the person predeceases you? So if you've appointed an individual as your trustee, you are transferring your assets to them, and then the person passes on, and you that you are transferring your assets to them, you are still alive. What happens? You know, so that's why the general recommendation, if you are looking at the instrument of a trust in your estate plan, is to appoint a corporate trustee. So I don't know if this person wants information on what it takes to be a corporate trustee. I think we can always have that conversation after now.
Okay. Can I answer Nosa's gifts? I mean, Nosa's question on gifts is very important because we see this a lot.
Yes, please, go ahead.
How can one properly effect a deed of gift of real estate when such real estate does not have a legal or registered title, only a Omonile receipt? So for that to happen, the owner has to apply for a C of O. With this Omonile receipt, you can apply for a C of O. Prepare your survey plan, apply to the Lagos State government, if it's in Lagos State, to issue your C of O in respect of that parcel of land. And after that has been done, you now have a legal right to transfer the title or gift the title to whoever the donee is. So I believe that answers the question. You can't just gift subject to their own risk, but legally you cannot gift it. You can maybe do it equitably, but not legally.
Great. Okay, thank you, Tola, for that. Thank you so much. There's someone we have, his name is Tolu Talabi. He has set up a trust, and for the next 5 minutes, we just want him to tell us why he decided to set up a trust and what has been his motivation, and what has been his experience thus far with Meristem trustees. So, Mr. Tolu Talabi, can we please have you?
Hello, good day all.
Good
My name
morning.
is Tolu Talabi.
Hello,
yes.
Sir.
How are you?
Fine, thank you. You're welcome.
Yes. Is my video all working? Okay, no problem. Okay, go ahead. If the audio is working, okay, no problem. Yes. Why did I set up? Can you hear me?
Yes, we can. Absolutely.
Okay. You asked, why did I set up a trust?
Yes.
Yes. I'm a retiree. I just retired a few years ago, and I wanted something like a one-stop shop for all the things I needed, the will, trust, and just as Adetola explained. In fact, what I did is to get over the third part that said it's difficulty, transfer. So now that I use the Meristem group, everything is under one roof. The trustees and the wealth management, of Meristem group. So the transfer is in-house, sort of. So that solves that part. So why I wanted everything is just to make sure I get an equitable distribution of my desires with one control in your lifetime and after you, essentially. So it's like a one-stop shop for me. I wanted everything in one roof.
Great, thank you. Thank you, Mr. Tolu. Just also to confirm, how would you describe your experience thus far with Meristem trustees? How would you describe it?
Yes, it's been good so far. They have been beautiful. They have been expository. They explain things. Most people don't know the fine details of doing things like this. So they explain everything. They are patient enough. They listen to you. You ask questions, they answer. And more so, like I told you earlier, I wanted everything under one roof so that it's easy, it's seamless. The wealth management, and the trustees, they're all in the same group. So far, so good. They've been good.
Great, thank you.
And the communication has been very, very good as well. In making the living trust. I have a living trust with them.
Oh, great. Thank you. Thank you, Mr. Tolu. We appreciate this. Thank you. Okay, there's a question here. It says, what happens when a sealed will at the court is burnt or stolen? That's an interesting one. What happens when the sealed will at the court is burnt or stolen? Damilola, you want to say something?
Yes.
Okay.
So typically you are lodging a copy of the will. So either you're doing that yourself or your solicitor, or a firm like Meristem Trustees that facilitated the drafting of the will is lodging on your behalf. That is not the only copy. So for as long as that individual is still alive, it's not likely that the court got burnt and you are not aware. So you are likely to be aware that this has happened, and then there will be provision made. Adetola mentioned something like that, even with the recent situation we had in Lagos, so that you can go lodge another copy. So you are expected to execute your will in several copies. For our clients, what we offer our clients when we draft their will for them is to we lodge on their behalf a copy. We provide, for some clients, they want to have a copy of the will and hold in custody by themselves. For a number of clients, they don't want to have any copy at all. So we also, we have off-site vaults that are well secured, that we also keep copies of such documents. So you don't have anything to worry about. The other bit is, if you said if it's burnt or if it's stolen.
Yes, at the court.
No, so since that's not the only copy, the reason why you are lodging it in the first instance is so that there's a record in the public that you have a will. You know, we've had situations where people passed on, and because the will wasn't lodged, it doesn't invalidate the will, but the fact that it wasn't lodged deprives the family of the knowledge that there's a will, because the lawyer who drafted it, the trust company may not even know that the person has passed on, you know. So that's why you usually would lodge a will.
Great. Thank you, Damilola. There's another question here. It says, would Meristem be willing to make cold calls to individuals identified as someone who should have a will or put together an estate plan? Will Meristem be willing to make cold calls to individuals that have been identified who should have a will or who should have an estate plan? If yes, who can they send that information to?
Okay, so please, someone should put on the chat room the email address, our trustee email address. You can send us an email with information. So I think I understand this question and the perspective from which this person is coming from.
Yeah.
More often than not, the conversations around estate planning can be difficult to have. I've seen situations where spouses are concerned about their partner's state of affairs, but raising it by themselves creates, it's like a red flag. When you are the one addressing your spouse about their estate plan, about their will, about, you know, and you know how we can be in Africa when someone thinks, Madam, why are you asking me about my will, or if I have a trust, do you have any plans? So we know that sometimes these conversations can be difficult to have. So we don't mind having that conversation on your behalf. Sometimes it's also the children who are concerned, you know, and they want to broach this topic with their aged parents. So it can be anything at all. So let's know what the situation is. We'll put heads together and see how we can step in to have those conversations without you being at the forefront. For some people, they just need that nudge. They just need someone to draw their attention to it, and that's all they require. And you mean well for them when you want them to put their plan, their estate together. So we can have conversations and we can step in.
Great.
Thanks.
And I can see that the contact has been shared on the chat room. So do well to send the information to that email. One more question, Damilola. It says, what is the ballpark estimate for this service? So I want to do an estate plan, I want to write a will, I want to set up a trust. What is the ballpark estimate for this service?
Okay, so quickly, let me just, for the purpose of the voice recording of this call, the email is trustees@meristemng.com, trustees@meristemng.com. You can share your email with that. So ballpark cost, either for drafting your comprehensive will or putting together your trust, there's typically a sign-on fee. So the sign-on fee gets us to begin to look at all the documents that is required, begin to put together so because we would have listened to you and we'll be advising on what we think is the best option. So the sign-on fee is typically 250,000 naira as sign-on fees, where we get to have all those conversations. Then we have the management fee. So for a trust client, because we'll be holding those assets in trust for you, we would have an extension of our asset management subsidiary providing asset management services for whatever type of asset it is that we are holding in trust. So there are costs to the management of such assets. So a case in point, if real estate is part of what we are holding in trust for you, and you want us to manage those properties and stand in your place, relate with your tenants, or whatever it is that you would be doing by yourself, you want us to do that for you. We'll work with our real estate division to provide that service, and that's and their fees will be based on the income you earn from such real estate. So it's usually between 5 to 10% of the income you earn from such real estate. The same thing to apply to other types of assets. As much as possible, we make it very easy. We don't have hidden fees. So you're either paying a fixed management fee per annum, we are paying a percentage of the overall assets that we are holding in trust for you. So that could be like a 1%, 0.75%, depending on the size of the asset. We also have options where a client can choose that the fees we earn should be based on the income derived from the assets that we are holding in trust. So that means that those assets are definitely income generating assets where we can now then benchmark our fees upon. But so those conversations can always happen outside of this call. We're willing to sit with you and have detailed discussions on this. Thank you.
Thank you, Damilola. Okay, there's someone here, Abdul Ganiu Ajile, who would like to ask a question. So I would like to unmute him and let him ask his question. So Mr. Ganiu, let's have you, please.
Okay. Good afternoon.
Good afternoon, sir.
Yeah. I want to ask whether your trustee estate panel of Meristem take care of Islamic inheritance estate issue.
Okay.
Whereby whatever you have will be shared according to Islamic dictate. If one now hands it over to you, is there a department that will be able to handle that effectively?
Okay.
Yeah.
Thank you. Thank you. Damilola, let's have you.
Yes. So we understand that, like I said earlier, that there are different circumstances for each individual. Well, for some is religious, there are tenets, there are requirements, you know, under the religion that you practice. For some, it is tribal, it is ethnic. So you have different things that apply for the different tribes and different jurisdictions. So for this, under the Islamic law, it's already, it's clearly defined what it should be. So we sit with the individual. So if the situation applies to you, we'll sit with you and administer in line with the Islamic law and document everything that needs to be documented in that regard. So that's what is important. You don't want a situation where you plan your estate outside and it conflicts with the provisions of the Islamic law that you practice. So we will sit with you to draft what covers your religious requirements.
Thank you.
Okay.
Thank you very much.
Thank you. Thank you, sir. Thank you, Damilola. I think we're finally coming to bed. The ship is about to bed. And I like to say it's been an exciting conversation thus far. Like we said, it's all about planning your estate in these times of uncertainty. Whether we like it or not, we cannot predict the future. But what we can do certainly is to plan. In the light of all of this conversation, I want to say Damilola will give a closing remark to all of this. But before she does that, it is important that we all make that bold step. Procrastination, they say, is a thief of time. No one knows what the next second holds. But what's important is we must think of our loved ones and ensure that plans are put in place to ensure that their fortunes and welfare are secured, even at our demise. So Damilola, I'd like us to round up this session. Thank you.
Thank you. Let me say a big thank you to each and everyone that has made out time to sit with us this morning to learn and to share. The idea of this webinars, the Wealth Preservation Series was born out of the need to provide education, to provide information so that as informed people, we are better positioned, you know, to take decisions that have far-reaching impact on our families and on our loved ones. Like we like to say over here in Meristem Trustees, if you love certain people, you will make provision for them. You would plan ahead for them. You would not want to leave them, you know, exposed to situations and circumstances that that would derail the plan that you already have laid for them. If you have young children who are very much dependent on you, you have physically challenged relatives that you really want to take care of, and you don't want a situation where you are at a loss as to or they are at a loss rather, if you are no longer there to take that decision for them. It's important that you bear in mind that these people exist, these people are precious to you, and you want to make that provision. Estate planning is simply giving what you have to who you want. It's your choice, and you don't want that choice to be taken away from you. So we're encouraging everyone on this call, if you do not have a plan, you haven't planned this out yet, please give us a call, send us an email. Let's have a conversation with you, and let's get you started. It does not have to be perfect from get-go. Start from where you are. Start from what is clear, what is very obvious. For some people, it's just about putting together a simple will where your retirement savings account is named, where where basic things that you have are named. Don't wait till you have several hundreds of millions or billions before you plan your estate. As long as you have assets that you have worked for, you have legacies that you want to protect and preserve, it's very important that you begin to put those steps in place, to protect that legacy and to ensure that your loved ones are well protected. And like we also joke around here, we say that indeed, when you are long gone and people are crying at your burial, let's be sure what exactly people are crying over. Let's be sure that the cry is because they really miss you, and not the fear of what lies ahead because you've just left them in a lot of chaos. So Meristem Trustees is your partner on this journey. You've come this far. We can take you further in your estate planning work. So please give us a call, send us an email, and we would love to work with you to get this done in good time. Thank you all for coming, and do enjoy the rest of your day. Omoife, over to you.
Yes, thank you, Damilola. And to our distinguished guests, we want to say thank you. And we'd like to say, look forward to the next Wealth Preservation series. It promises to be exciting, life-changing, and worthwhile. Once again, thank you. Thank you so much.
Omoife, I believe the recordings will be made available to all attendees. I've had individuals asking that.
Yes.
Okay. And if for any reason we haven't answered your question, please forgive us. Send us an email, trustees@meristemng.com. We will be available to answer your questions if for any reason we haven't answered those questions. Thank you.
You've reached the stars, now let's see you conquer galaxies. You've gone for gold, let's show you to.
What kind of success do you look for?
No gold.
If it's the small kind, you can go at it alone. If it's huge, no matter how good you are on your own, you need partners. Partners who can help maximize the potential of your wealth. You've come this far, let's take you further.
Meristem, let's grow wealth for you.